Welcome to week 7, and this week we'll be focusing on drafting contracts. Now, we've already looked at some of the basic principles for drafting a contract in week 1 when we looked at some of the very basic components of drafting many documents, such as considering the purpose, the context, the reader, and your instructions. The fact that using lists can be a very useful and effective manner of communicating information, and that very careful phrasing is required when you are dealing with calculations of time. So it's important to make sure that you review those materials as well as the study guide for this week to really help you prepare for the workshop activity. Now, Module 1 talks about identifying foundational information and presenting that first in the document, and this is explored in more detail in relation to contracts specifically in the study guide. It's important, though, that when we're thinking about a contract, we need to always bear in mind the basic components of a contract, what is required to ensure that you have a valid and binding contract. That means that you need to identify the parties, you need to ascertain what is being provided and the consideration that is being provided in return. You then need to extend beyond those basics and think about more specific details. Not only, for example, where are the goods to be delivered, but who bears the risk in transit. So you need to take each basic component of the contract and then try and drill into some detail and then clarify that with your client and then provide for that in the contract. Remember that one of the primary aims of a contract is to avoid potential litigation in the future by providing clarity. It's only possible to achieve that if you use your little crystal ball and try and anticipate all the potential things that might happen in the future, all of the information that the parties will need to help them govern their relationship, but also all of the potential things that they might disagree about, and then cater for those in your work. So risk analysis really should be part of the process of preparing the draft. It's important to plan the draft before you start writing so that you can see where the gaps are that you need to fill in by obtaining client's instructions and then drafting an appropriate clause. Note that the contract is not just intended to cover obligations. You should also think about the rights of the parties as well. What rights should they have? Are they conditional rights or absolute rights? Think about consequences for breach of a relevant term. So where we've got, for example, an obligation and it's breached, what rights can the party exercise in response? Note that as litigation is a costly exercise, it's likely that the parties will want a dispute resolution clause of some kind. Now, you must discuss this with your client and explain the range of options available, take clear instructions, and then cater for that in the draft. On a practical level, contracts often involve the exchange of drafts between the parties. It's not the case, usually, that one party produces the contract and the other just happily signs. So you may have to go back to your client for further instructions if the other side proposes amendments. And often there can be some toing and froing before a middle ground is found between the parties. Regarding the format of the contract, you must bear in mind that it must be easy to navigate. So the use of headings to each particular clause is really important. Consider a contents page if it's a lengthy document, and consider whether it's important to have definitions in one place. It's important to ensure that the essential clauses, those that form the very basis of the agreement that will operate at all times, it's important that those feature at the beginning of the document. Then, for subsequent clauses, think about grouping things that naturally go together. So, for example, when you're talking about payment, you might have one term on when payment is due and a second clause or term on how payment is made. Those naturally go together and should therefore be successive in the document. Now, the workshop activity for this week is a peer review exercise. Prior to attending the workshop, you need to swap your draft contract with someone else and provide feedback to each other. If you don't have anyone to swap with, look on the forum to see if anyone else is looking for a partner. As a last resort, you could post it on the forum and then ask for comments, and then make sure that you comment on someone else's contract that has been posted on the forum. It's important that you record your feedback that you provided and also received in your drafting portfolio. Now, you may feel really nervous about putting your work out there and receiving feedback on it, and that's perfectly understandable. But you will have to get used to others looking at your work, especially in practice. Your supervisor will most definitely comment on your work. Mine used to use a bright red pen. And some of your work will, of course, end up on the file for everyone to see. Anyone else working on the file will review the file to get up to speed, and that means that they're likely to read the letters that you've written or your draft documents so that they can understand what has happened to date and what they need to do in the future. Note that aside from people in your firm, if you write a letter, your opponent will read it or your client will read it. And documents prepared for a hearing, like an application for a court order or a statement of claim, will be read by a judge. So your work is always on display in legal practice. Now, gaining feedback from others will give you a new perspective on your own work, so it's really worth doing. This will not only introduce you to feeling a little bit uncomfortable by exposing yourself to criticism, by putting your work out there, it will get you used to that feeling, but it's also going to give you a lot of insight into your work, and that's really valuable. It's going to help you identify how to improve your work, and by offering feedback to another, by acting as a tutor, providing feedback to others, it will actually help you learn what is important, what needs to be focused on, what aspects of your work can improve. You're going to be much more critical of your own work in the future. So in essence, acting as a tutor providing feedback enables you to become a reflective practitioner, and that's a skill that you really will need for legal practice. The only way that you're going to become that associate, senior associate, and partner is to grow, and the way that we do that is by reflection, identifying what we do well, what we need to improve, and how we go about improving it. Just before you go, I'd like to give you some tips about how to provide feedback to others about their work. The first one is to think about how you would like to receive feedback. How would you like feedback to be expressed to you? How would your tutor provide feedback to you? And then mirror that when you're providing constructive criticism to the other student. Tip number 2, don't try and do too much. You don't have to comment on every single thing across the entire paper. Stick to 1 or 2 good things that should be built upon, and 1 or 2 things that really need improvement, and make sure that you not only point out those problems, but you also provide suggestions as to how they can actually go about fixing those issues. Number 3, remember the difference between feedback and proofreading. Proofreading is an editing process. When we're proofreading, we're looking for typographical errors, grammatical issues, and whether sentences are clumsy and need rephrasing or are too complex. Don't be an editor. Actually be a tutor and provide meaningful feedback on how to improve the content. So feedback is much broader. Consider the structure, the content, the expression. Be that tutor rather than the editor. And finally, it's tempting to tell someone what they want to hear. We all want to be kind, and that's perfectly normal. It's a natural feeling, but you're really going to give them the most benefit by actually being truthful and honest. Just make sure that you express it in that constructive feedback manner. Finally, try and avoid being personal with your feedback. So think about the difference between these 2 sentences. The first one is, this sentence is confusing. And the second sentence is, you have drafted this clause in a confusing way. One is more personal than the other. So the latter, you have drafted this clause in a confusing way, says the word you, it's targeted at that person, whereas the former, this sentence is confusing, is only really commenting on the actual work itself. Now, although you might not be offended by the difference between those 2 sentences, some people might be. So err on the side of caution and make sure that you direct the feedback at the actual work rather than associating the individual with that work. Okay, that brings me to the end of this video. I'm looking forward to seeing all your drafts in the week 7 workshop, so I'll see you then.